we have actually been sliding in terms of, the policy attractiveness, as a mining jurisdiction, which is something that has to be rectified.
The Minerals Council of South Africa, formerly known as the Chamber of Mines, has welcomed a recent High Court judgment regarding the empowerment provisions of the Mining Charter of 2018. Joining me to discuss is Tebello Chabana. He is an executive and head of stakeholder relations and transformation at the Minerals Council. Tebello Chabana, welcome to the Center for Risk Analysis. Could you provide our viewers with some context? Why did you approach the court on this matter, and what is your assessment of this judgment?
Yeah, it was important for us to get some final clarity relating to a few issues. The one related to the once empowered, always empowered, or as we refer to it, continuing consequences of past transactions, where a mining entity has entered into, a bona fide BE deal, and where, say, the black shareholder sold and exited that BE deal. Does the mining company continue to have those BE credits? Now, this issue was resolved in 2018 with regards to where a situation where the BE party sold during the duration of the mining right. So the court in 2018 said that, yes, you will get those credits for the duration of the mining right. However, the mining charter sought to essentially change the situation, as we put it, relating to transfers and renewals. Because the reason why I say change is that the MPRDA, which is the framework legislation, we say is pretty clear. The MPRDA basically says that you do not need to re-empower in the event of a renewal of a mining right and in the event of a transfer. So that is the issue that the court had to decide on. And the court basically confirmed our interpretation that even in the context of a renewal or a transfer of a mining right, you do not have to re-empower. So it confirmed this continuing consequences of past transactions in the context of a mining right and renewal and transfer. That was the first bit of clarity that was given. The second bit of clarity related to the actual legal nature of the mining charter. We had always said that in terms of Section 100, subsection 2 of the MPRDA, it is clear that the mining charter is policy. It is not legislation. It is not subordinate legislation. It is policy. And the court confirmed that. You will recall that the first iteration of the mining charter was signed by the parties. It was almost like a compact. And I think over the years, it developed a bit of a life on its own, to the extent that some were wanting it to be legislation, but it is not. But it's important to note that the charter is not the only instrument that the minister can use to regulate transformation in the industry. There are regulations, there are social and labor plans that we adhere to. So there are other levers that the minister can use to regulate transformation.
Enjoying this analysis? Click here to sign up for our 30-day free trial for more content from the CIA.
But Tebello, it seems that the transformation agenda is actually frustrating new investment in mining in South Africa, and that this puts a whole lot of onerous burdens on particularly new mine investment. So in 2020, there was only about $77 million worth of exploration in South Africa. And that accounted for less than 1%, less than 0.5% of global minerals exploration. And I mean, the consequences that we have South Africa now slipping down the ranks in terms of mining competitiveness. It's only the 6th most competitive in Africa, let alone the world. So, it seems that the entire regulatory framework is misaligned with the needs of industry. What are your thoughts on that?
Yeah, I certainly do agree with you in that the regulatory framework at the moment is certainly not optimal. We definitely think we need a lot more certainty. We need a lot more predictability and consistency. So you're right. Is it as a result of the BE requirements alone? I don't think so. I mean, there are a lot of circumstances, and this element of the BE legislation, now that we have clarified, will certainly provide that certainty. But, South Africa has to do a lot more to attract, exploration spend. As you say, we're getting less than 1% of the global spend. We need to ensure that the country is a lot more prospective, that information has to be made available, and we've got to try to ensure that, that the funding for exploration can actually be existent essentially in the country. If you do not have, that risk capital available, you're not going to get the exploration. So that's part of the problem. The other challenges that we face in an SA context, relate to power. The challenges that we've had with Eskom, now also with Transnet in terms of logistics, your bulk commodities are really experiencing some challenges, and those are some of the things we have to work through. So you're right. I think all of these have led to South Africa certainly sliding. If you look at the Fraser Institute rating, we have actually been sliding in terms of, the policy attractiveness, as a mining jurisdiction, which is something that has to be rectified.
And of course, at the moment, as we speak, there is a commodities super cycle. Exports are up, and the state is collecting a lot more revenues, particularly from mining companies. Do you not think that this gives mining companies more leverage in terms of arguing for a more conducive policy environment in South Africa?
No, absolutely. I think we all assume that the fiscus is appreciative of the gains that mining companies have made and their contribution to the fiscus at the moment. It has really helped to plug a hole that was at issue, in the context of COVID, in the context of our economy that is really stuttering at the moment. So one hopes then that our regulators will actually see clear to, let's help mining be the flywheel of the economy. Let's help mining be the catalyst that drives that economic growth in the South African context. So what do we need to do that? Let's resolve the Transnet issues. Let's resolve the power issues. Let's resolve some of the regulatory uncertainty. So we're hoping that, yes, it will give us a little bit more leverage. And I think our regulator is actually seeing that. I mean, Minister Mantashe has committed to trying to resolve some of the blockages that we have. The outstanding mining and other licenses. They've really now committed to, getting rid of that backlog, which was dating back to, 5-6 years of, some mining rights held in abeyance there. That is not acceptable. We've got to be actually, getting these licenses in these approvals on time. So yeah, that's the work that's what we're trying to work on at the moment.
Yeah, I suppose there are two separate questions. The one is the certainty of policy. And the other is whether policy itself is actually enabling or disenabling of investment. And,
absolutely.
I think you can have policy certainty, but if those are inhibitive policies, then does that really help you?
No, not at all. You've got to have both. I mean, you're right. You can have bad legislation that doesn't change, and there you've got certainty. So you're right. It's got to be a combination of predictability. It's got to be consistency, but at the end of the day, it's got to be competitive. So, and I think that's where the big challenge is for South Africa. If you look at the Fraser Institute ranking, if you look at South Africa as a potential investment destination, looking at the minerals in the ground, it actually rates quite well. And yet, when you look at South Africa from a policy perspective, we're somewhere now. Is it third or fourth quartile? So it's basically showing you the two are not aligned, that there seems to be very good minerals in the ground in the South African context, and yet our policy environment is really not as conducive as it should be. So you're right, the two have to be aligned in order for it to really work well for our country.
Now, Tebello, it certainly seems that the Department of Mineral Resources can barely get its head out of a paper bag at the moment. What about the issue of procurement? Because that is a big pillar of the BEE framework, and it affects mining quite critically as well. In your submission to the court, you highlighted that many of the procurement objectives or targets that were being set were unrealistic and unattainable. Do you care to elaborate on that for our viewers?
Yes, we'll do. I think you're right. I mean, procurement is a critical element of transformation, which we support. And, previous charter, you'll see how, if our report, how well we did as an industry. And we don't object to the BEE targets per se in the current mining charter 2018. The big challenge relates to local content. Now, we as an industry are very much in favor of trying to reindustrialize the country, supporting local content, but a 60% local content target to be achieved in a 5-year period is unreasonable. I mean, if you look at the motor industry with the MIDP and its program, they had the majority of government grant funding going to it. It was well supported. And by the way, they've had a much longer period, over 30 years to get to a 60% local content target. And we're expected to reach it in 5 years, sorry. And by the way, we don't even manufacture that equipment. We have to import it. So that is really the challenge that we had with this local content target, to say it's just not achievable in the time frame that we've been given.
Tebello Chabana, thank you very much for joining me on the CRA channel. Let's hand over to you, our viewers. What do you think is the impact of empowerment regulations on the mining industry? Leave your thoughts in the comment section below, and do remember to give this video a like and subscribe to the channel. My name is David Ansara. Until next time, take care.